Judge Leonardo Grecco, hello. A pleasure to have you with us to discuss the foreign jurisdiction clauses in bills of lading under the view of the Brazilian courts.
Hello, Lucas. The pleasure is all mine.
Brazil is a relevant player in terms of international commerce and maritime transport. Even though international contracts of carriage often bring a foreign jurisdiction clause, before the new Brazilian Code of Civil Proceedings, Brazilian courts would normally accept jurisdiction for a contractual dispute in such cases. Do you feel that this has changed after the new code?
This is a good observation indeed, and my short answer to that will be yes. The new Code of Civil Procedure brought a new provision in Article 25, which establishes that it's not up to the Brazilian court to judge a case when there is a clause of exclusive foreign jurisdiction established in an international contract and raised by the defendant. Since then, the vast majority of the courts are dismissing claims in Brazil under the foreign jurisdiction element.
If I may add, I think it is of great importance that the Brazilian courts are respecting the contractual provisions and providing legal safety to what has been agreed upon by the parties. It is worth to remember that we are talking about parties that are regularly involved in international trade and that are using international commerce to boost their production chain, thus seeking profit from it.
Indeed, the Brazilian courts should primarily aim to respect the intention of the parties in the contract, and a judge should refrain from changing what the parties had agreed, unless, of course, if the provision seems illegal or abusive towards a vulnerable party. And there is often no vulnerability in international trade involving professional companies, reason why the Brazilian courts should not intervene to protect one contractual party in detriment of the other.
And this is what Judge Messias would call the babysitter state. If the matter involves private interest of private entities in an international contract, the Brazilian state should not interfere to babysit one party that did not bother to negotiate well the contractual provisions and only aim to do so when a dispute arises.
And in that case, being a valid contract among professional parties, the state should in fact not interfere to change what has been agreed.
Would this situation be the same if instead of the cargo owner, the claimant is a subrogated cargo insurer? Would such foreign jurisdiction clause still apply?
That is a very interesting question. My short answer to that question would be yes as well, but perhaps this could be a topic for a next podcast.
That's a great idea for our next episode. Many thanks, Judge Leonardo Grecco.
Many thanks, Lucas, for the opportunity and participating.